Thank you, Mr. Chairman. I would say the most notable thing about the preamble is what it doesn't include in the selective history that it chooses to put in it. But before I go into some of those omissions in the preamble, I'd like to respond to something Materia Ture said, which was that the bill is discriminatory because it protects existing Maori and freehold titles. Now, I disagree with this bill, and I don't think this bill should proceed, and I don't think this bill will provide an enduring settlement, but I disagree with her assertion that that is discriminatory of Maori or discriminatory of non-Maori, and I also disagree with her implied assertion that the common law right to a customary title would prevail over an existing freehold title that has been established, because it's absolutely clear from a reading of the Ngāti Apa decision, in my opinion anyway, that a customary interest would not have been found in an area that was already subject to a freehold title. The tests of control that have been applied in overseas jurisdictions to establish a customary marine title, as it is called in this particular piece of legislation, are quite high tests, and they would be obviated by an instance where someone has been conferred a title. So we ought to remember that what is in debate here is a common law interest that is unextinguished, and there are many acts that can extinguish those customary interests, and the conferring on someone of a collective or freehold title would have extinguished customary interests that were inconsistent with that freehold title. And I don't think there's any doubt in law about that. I would also note, in respect of the assertion that that is somehow discriminatory against Maori, that a lot of the titles that are being protected by those particular clauses in this legislation are in fact Maori titles. They're collective titles. They're sometimes Maori freehold titles that extend into the foreshore and seabed areas. So rather than this being discriminatory against Maori or discriminatory against some other group, actually that same rule is applying to everyone. And in any event, I would suggest to Materia Ture that those areas would not qualify in any jurisdiction around the world that has looked at these issues as being still having extant, unextinguished customary titles. I want to return to some of the other problems with the preamble. We have in the first paragraph to the preamble saying that the Foreshore and Seabed Act 2004 was enacted partly in response to the Court of Appeal's decision. Well, what it doesn't say is that at the time the exaggerated rhetoric that was coming from both sides of the dispute was saying things that were wrong and were racking up race relations. And I've said in prior parts of this debate, and I don't shirk from saying it again, that it was a septic time politically at that time, and race relations were being irresponsibly racked up, amongst others by Don Brash, the then leader of the National Party, against by Bill English, who was also saying to people, that they wouldn't be able to have a barbecue at the beach when the legislation protected rights of public access. Bill English was saying people wouldn't be able to have a barbecue at the beach. And Jerry Brownlee was the third person who was the leader of those intolerant and incorrect things that were being pushed by the National Party. They were three very senior people in the National Party at the time. Don Brash was leader. Was Bill English deputy at the time? I can't recall. He was their finance spokesperson anyway, I think, at the time. And Jerry Brownlee was also in a senior role and had the spokesmanship role for Maori Affairs at the time on behalf of the National Party then in opposition. They racked this up and they said inaccurate things about what was the effect of the Foreshore and Seabed Act. We also had Hone Harawira, and I've said this previously to Hone Harawira, in my opinion, misrepresenting the Ngāti Apa decision also. He said that the effect of the Ngāti Apa decision was that Maori owned the foreshore and seabed around New Zealand, and at times he gave the impression to New Zealanders that that was true in respect of the foreshore and seabed around the whole of New Zealand, and that the rights that Ngāti Apa found in respect of Maoridom were tantamount to freehold property rights. And that was wrong too. And that was one of the things that drove the fearful response from some of the redneck reaction in New Zealand who thought, well, hell, I can't live with that. Well, they didn't need to live with that because that was never true either. Mr. Speaker, those two things are omitted from the preamble, and they ought to be there because they are very relevant to where we got to in that Act. Now, the Act wasn't perfect, and I actually agree I agree with the special rapporteur from Mr. Chairman, with the special rapporteur that the greatest problem with the Foreshore and Seabed Act was not that it declined a right of people to go to court to prove that they had an unextinguished customary interest, what we're now calling customary marine title, but what we called under the Foreshore and Seabed Act a territorial customary right. It wasn't that you couldn't go to court to establish that existed prior to the Foreshore and Seabed Act. The problem was that you couldn't get recognition of it of court, and you were flicked back to a negotiation with the Crown. And that effectively left people, and I agree with John Boscawen on this, that left people at risk of grace and favour agreements with a future government to have their property right recognised. They shouldn't be reliant upon a future negotiation with the Crown for that. If it exists and the court finds it exists, then it should be recognised. It shouldn't be a matter of negotiation with the Crown. And it's on that fundamental point that the Labour Party said, we agree that the existing Act needs to be changed. Now, that could easily be done by way of amendment. It could have been done by way of amendment to the existing Act, and we would have preferred that. We could go along with repeal and replacement legislation if it was of that limited effect, but of course that isn't the effect of this legislation. I want to, in the short time that I've got for the remainder of this term, to take up this issue of the process that's been adopted. Now, we heard the Attorney and the Chair say that the prior process for the Foreshore and Seabed Act 2004 was rushed. In fact, it received royal assent a year and a half after the Court of Appeal decision in Ngāti Apa. There were hearings up and down the country. There were thousands of submissions. The big difference in process was that the Select Committee did its job properly. It was allowed to finish its job properly. It was allowed to properly report to the Parliament as to what the effect of the legislation was. And in aid of that, it had legal advice from Paul McHugh, a Cambridge professor learned in international common law property rights, customary rights. That Select Committee had the benefit of that advice. That Select Committee reported back to Parliament as to what was the legal effect of the Foreshore and Seabed Act compared with the common law right. In this legislation, we do not have the benefit of either the Crown's advice received from Crown law, because access to that has been blocked by the Attorney-General. The Attorney-General is entitled to claim privilege and not release that advice. But what was improper was the Select Committee blocking the Select Committee getting legal advice. And we, to this day, do not know how to compare the legal test compared with what would have been found at common law if this was back at the courts. And that is wrong. That is very, very poor process. We're left with issues. Now, we are codifying this test in a way that Maori say is unfair to Maori, and some non-Maoris say is unfair to non-Maori. We've got this enduring sore left in New Zealand because we haven't properly dealt with that issue and the absence of legal advice. But it's abundantly clear that this is not going to be settled by Parliament. We've got the Maori Party, their leader, their deputy leader, their senior whip saying it is but a step and they don't accept that it fairly settles the issue. We have Hone Harawira having left the party and saying he doesn't accept that it's a fair settlement, so that the government, to pretend that this is in full and final settlement of the framework to determine foreshore and seabed claims, is wishful thinking and wrong. Mr. Chairman, the issue as to the process was also touched on by Mr. Boscawen. We had a 500-page departmental report, lots of technical issues raised by it. 500 pages. I am one of the members of that Select Committee. I actually like to think I'm a reasonably thorough member of Select Committees, and I try to read my papers. This was circulated by email on the Friday. It was received in our offices on the Monday. This is the Monday after Waitangi Day over the weekend, and it was deliberated upon it was considered by the Select Committee on that Tuesday afternoon. I, like most members of the committee, received it on the Tuesday morning. I went along to the Select Committee on the Tuesday afternoon, and it was pushed through consideration by the National Party and Maori Party members without any member having read the whole of the report. Paul Quinn says that he read the whole of the report. He did not. Even he on that afternoon acknowledged he had only got through 2/3 of the report. I had not had a chance to read it properly.